ಏನ್ ಅಫೆನ್ಸ್ ಅಮ್ಮ? ಏನ್ ಸಿಕ್ಕಿದೆ ನಿಮ್ಮ ಹತ್ರದಿಂದ? ಏನ್ ಸಿಕ್ಕಿದೆ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀನಿ. ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಟೈಮ್ ಕೊಡೋಣ. ನಿಮ್ ಕಕ್ಷಿಗಾರರು ಜೈಲಲ್ಲಿ ಇದ್ದಾರೆ, ನಿಮ್ ಸೀನಿಯರ್ ಊರ್ಗ್ ಹೋಗ್ಬಿಟ್ಟಿದ್ದಾರೆ, ಅವನ್ ಅಲ್ಲೇ ಕೊಳಿತಾ ಇರ್ಬೇಕು. ಇವತ್ತೇ ಲಾಸ್ಟ್ ವರ್ಕಿಂಗ್ ಡೇ, ನಿಮಗ್ ಟೈಮ್ ಬೇಕಾಗಿದೆ, ಕೊಡೋಣ. ರಿಕವರಿ ಏನು ಅಂತ ಗೊತ್ತಿಲ್ಲ, ಫೈಲ್ ತಂದಿಲ್ಲ, ಓದಲ್ಲ, ಸೀನಿಯರ್ ಹೇಳಿರೋದು ಬರೇ ಟೈಮ್ ಕೇಳು ಅಂತ ಅಷ್ಟೇ ಮಾತ್ರ ಮಾಡೋದು. ಮಿಕ್ಕಿದ್ದೇನು ನನ್ ಕೇಳ್ಬೇಡಿ. ಕೊಟ್ರೆ ಕೊಡಿ, ಇಲ್ಲರ ವಜಾ ಮಾಡಿ. ಇದೇ ನಾನ್ ತಮ್ಮ ಸಬ್ಮಿಷನ್ನು. ಮತ್ತೆ ಹೆಂಗಾರು ಮಾಡ್ಕೊಡಿ. ರಿಲೀಸ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆಫ್ಟರ್ ವೆಕೇಶನ್. ಈ ವಯಸ್ಸಿನಲ್ಲಿ ನಿಮ್ಗೆ ಎರಡನೇ ಮದ್ವೆ ಆಗೋದ್ ಕಷ್ಟ. ಹನುಮಾನ್ ಪಿಶಾಚಿ ಬಂದ್ಬಿಟ್ರೆ ಲತೀಫ್ ಅವ್ರೆ ಬಹಳ ಕಷ್ಟ. ತೆಲುಗಲ್ ಗಾದೆ ಇದೆ, ಅನುಮಾನಂ ಪೆದ್ದ ರೋಗಂ ಅಂತ. ಒನ್ಸ್ ಯು ಸ್ಟಾರ್ಟ್ ಡೌಟಿಂಗ್ ಯುವರ್ ಸ್ಪೌಸ್, ದೇರ್ ಕೆನಾಟ್ ಬಿ ಎನಿ ಎಂಡ್ ಫಾರ್ ದಟ್. ಕನ್ನಡಿ ಹೊಡೆದೋದಂಗೆ. ಎಷ್ಟೇ ಚೆನ್ನಾಗಿ ನೀವು ಅರಾಲ್ಡೈಟ್ ಹಚ್ಚಿದ್ರು, ಫಿಕ್ಸ್ ಮಾಡಿದ್ರು ಆ ಗೀಟ್ ಕಾಣ್ತಾನೇ ಇರುತ್ತೆ. ಬೇಕಾದ್ರೆ ಪ್ರೀತಿ ಉಕ್ಕಿ ಹರಿದ್ರೆ ಬಂದ್ ನಮ್ಮ ಹತ್ರನೇ ಕೇಳಿ, ಅವಾಗ ನಾನ್ ಬೇಕಾದ್ರೆ ಕಂಡೀಷನ್ ಮಾಡಿಫೈ ಮಾಡ್ತೀನಿ. 13 ಲಕ್ಷಕ್ಕೆ ಏನ್ ಮಾಡ್ತೀರಿ ಹೇಳಿ? ಅದಾಗೋ ತನಕ ಇದಾಗಲ್ವಲ್ಲ, ಏನ್ ಮಾಡೋದು? ನೋಡಿ ಏನ್ ಮಾಡ್ತಿರೋ. ಈಗೇನೋ ಅವಳ ಜೊತೆ ಇರ್ತಿರೋ ನೀವು, ಇರಲ್ವೋ? ಹೆಂಗಿರ್ತೀರಿ? ತಿರ್ಗಾ ಹೆಲ್ಮೆಟ್ ತಗೊಂಡು ನಾನು ಸಾಯಿಸ್ಬಿಟ್ರೆ ನೀವು ಬೇರೆ ರೆಸಿಡೆನ್ಸ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಡೋಂಟ್ ಟ್ರೈ ಟು ಸ್ಟೇ ವಿತ್ ಹರ್. ಇದೆಲ್ಲ ಎಲ್ಲಿಗೆ ಬಂದ್ ಮುಟ್ಟುತ್ತೋ ಗೊತ್ತಿಲ್ಲ, ಆಯ್ತಲ್ಲ? ಬಿಕಾಸ್ ದಿ ಅಪ್ರೆನ್ಷನ್ ಈಸ್ ಲೈಕ್ ದಟ್. ಟು ಸ್ಟೇ ಅವೇ. ಅಲ್ಟಿಮೇಟ್ಲಿ ಹೊಂದಾಣಿಕೆ ಆದ್ರೆ ಅಲ್ಲೆಲ್ಲ ಇದೆ, ನೋಡ್ಕೊಳ್ಳಿ ಏನಿದೆಯೋ. ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಜಡ್ಜ್ ಮುಂದೆ ಹೋಗಿ ಒಟ್ಟಿಗಿರ್ತೀವಿ ಅಂತ ಕೇಳ್ಕೊಂಡ್ರೆ ಉಂಟು. ವೆನ್ ಯು ಫೈಲ್ಡ್ ಎ ಕೇಸ್ ಅಂಡ್ when you are facing a charge under section 307 IPC, allowing you to stay with the complainant in the same house may not be justified. So we'll impose that condition. 307 ಆಗುವಂತದ್ದೇನಿರುತ್ತೆ, ನಾನು ಪದೇ ಪದೇ ಹೇಳ್ತಾ ಇದ್ದೀನಿ, ಇಂಜುರಿ ಗ್ರೀವಿಯಸ್ ಇದ್ರೆ there are other sections in the IPC. 326 ಇದೆ, ಅಲ್ಲೂ ಲೈಫ್ ಇಂಪ್ರಿಸನ್ಮೆಂಟ್ ಇದೆ. ಒಂದೇಟ್ ತಪ್ಪಿಸ್ಕೊಂಡ್ರೆ ಇನ್ನೊಂದೇಟ್ ಹೊಡಿದಲ್ನ ಯಾಕೆ ಬಿಡ್ತಾರೆ? ಕೊಲ್ಲೋ ಉದ್ದೇಶ ಇದ್ರೆ. ಆರ್ಡಿನರಿ ಸೊಳ್ಳೆ ಹೊಡಿವಾಗ ನೋಡ್ತೀರಿ, ಹಿಂಗಂತೀರಿ, ಸಿಕ್ಕಾಕೊಳ್ಳಲ್ಲ. ಇನ್ನೊಂದ್ಸತಿ ಟ್ರೈ ಮಾಡ್ತಿರೋ, ಇಲ್ಲ ಬಂದ್ ಕಚ್ಲಿ ಅಂತ ಬಿಡ್ತಿರೋ. ಅಂತದ್ರಲ್ಲಿ ಪ್ರಿಪೇರ್ ಆಗಿ ಹೋಗಿ ಮೋಟಿವ್ ಇಟ್ಕೊಂಡು ಇವತ್ತೊಂದ್ ಗತಿ ಕಾಣಿಸ್ಬೇಕು ಅಂತ ಹೇಳಿ ಮುಹೂರ್ತ ಫಿಕ್ಸ್ ಮಾಡಿ ಓದೋನು ಒಂದೇಟ್ ತಪ್ಪಿಸ್ಕೊಂಡ್ಬಿಟ್ಟ ಅಂತ ಅನ್ಬಿಟ್ಟ ಮಾತ್ರಕ್ಕೆ ಆಯ್ತು ಇವತ್ ಬಚಾವಾಗಿದ್ದೆ ಹೋಗು ಅಂದ್ಬಿಟ್ಟು ಬಂದ್ಬಿಡ್ತಾನ? ಮತ್ತೆ ಅದನ್ನೆಲ್ಲ ಹೇಳ್ಬೇಕು ನೀವು 307ಗೆ. ಗೊತ್ತಾಯ್ತಲ್ಲ? 307 ನಲ್ಲಿ ಅಟೆಂಪ್ಟ್ ಟು ಮರ್ಡರ್. ಸೊ ಮರ್ಡರ್ ಆಗಿದೆ, ಪರ್ ಚಾನ್ಸ್ ಅವ್ನು ಬಚಾಯಿಸ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದಾನೆ. ಸೊ ಇಲ್ಲ, ದಿ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಹ್ಯಾಸ್ ಟು ಎಸ್ಟಾಬ್ಲಿಷ್ ಆಲ್ ದೀಸ್ ಥಿಂಗ್ಸ್, ಅದರ್ವೈಸ್ 307 ವಿಲ್ ಗೋ ಅವೇ. ಕರೆಕ್ಟ್ ಅಪ್ಪ? ಹೊಡೆದಿದ್ದೀವಿ, ಹೆಡ್ ಹೊಡೆದಿದ್ದೀವಿ, ಹೆಲ್ಮೆಟ್ ತಗೊಂಡೇ ಹೊಡೆದಿದ್ದೀವಿ. ಆ ಘಟನೆಗೆ ಮೋಟಿವ್ ಏನು? with whether that incident has occurred at the spur of the moment or it was a premeditated. That is it is just ಗಲಾಟೆ ಬೇಕಲ್ಲ. ಓದಿ, ಅವಾಗ ನೀವು ಓದಿದ್ರೆ ಗೊತ್ತಾಗ್ಬಿಡುತ್ತೆ ನಿಮ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ನ. ಎಸ್, ಬರ್ಕೊಳ್ಳಿ. ಹಾರ್ಡ್ ಶ್ರೀ ಲತೀಫ್ and learned HGP petition under section 439 CRPC with the following prayer. Next para. Brief facts of the case are as under. Shashikala R lodged a complaint with Kushal Nagar Town Police on 14th January 2023, which was registered in crime number 7/2023 for the offence punishable under section 498A, 307, 504, read section 504 IPC. First, next para. List of the complaint governments reveal that the complainant is working as a head constable in Kushal Nagar Town Police Station and is residing in the police quarters. About 11 years earlier, she has married KG Nagendra and there are 2 children in the marriage, aged 9 years and 3 years respectively. First, it is her contention that her husband is a rate drunkard. ಹೌದಾ? ಡ್ರಂಕಾರ್ಡ್ ಇಂಪಾರ್ಟೆಂಟ್. ಟೀಚರ್ ಆದ್ರೆ ಅದು ಇಂಕ್ರಿಮಿನೇಟರಿ ಆಗಲ್ಲ. Great drunkard, and he had borrowed money from all possible sources and has become a defaulter. First, the loan of rupees 13 lakhs is made, a sum of rupees 13 lakhs is borrowed by her husband as loan from different people, and in that regard, there were serious differences between the complainant and the accused in their matrimonial relationship. First, there was a annual sports meet between 14/11/2022 to 19/11/2022 at Madikeri, and complainant and her friends had participated in the annual sports meet, and they had commuted from Kushalnagar to Madikeri in the car of one of her colleagues by name Sandeep by sharing the petrol charges. First, in that regard, the accused petitioner has entertained doubt as to the fidelity of the complainant and picked up the quarrel. First, in the quarrel, the accused had assaulted the complainant with helmet on her head, resulting in injury. First, based on the complaint, police registered the case as aforesaid and filed the charge sheet against the matter, and inter alia arrested the petitioner and took him to custody and then filed the charge sheet. First, Netpara. The charge sheet materials reveal that the complainant has sustained simple injury. First, Netpara. Whether at all the attempt made by the petitioner to seek for grant of bail is seeking grant of bail is rejected by the learned district judge in CMIS number 53/2023 by order dated 23rd February 2023. Thereafter, petitioner is before this court. Next para. Sri Latif, learned counsel for the petitioner, vehemently contended that even assuming that the entire material on record is to be appreciated, is to be accepted as true for the purpose of argument, no ingredients whatsoever are made out to attract the offence punishable under section 307 IPC and therefore sought for grant of bail. First, he also pointed out that since the charge sheet is filed and the petitioner is a teacher and is having permanent residence, continuation of the accused petitioner in judicial custody is no longer warranted and sought for a grant of bail. Per contra, next para. Per contra, learned HCGP opposes the bail grounds by reiterating the grounds urged in the objection statement. First, he also pointed out that petitioner had the habit of attacking the complainant for silly reasons, and the same was tolerated by the complainant all these years only with an intention to maintain the matrimonial relationship for the sake of the children. And when the petitioner has gone to the extent of assaulting the complainant on her head with helmet with an intention to take away her life, she could no longer tolerate the same and then approached the police, and therefore, petitioner is not entitled for grant of bail. First, next for in view of the rival context of the parties, this court perused the material on record meticulously. Next para. On such perusal of the material on record, it is seen that the incident has occurred on an unfortunate day when the complainant had participated in the annual sports meet, and for that purpose, she had traveled in the car of a colleague of the complainant. First, the accused petitioner doubted her chastity and picked up the quarrel. In the spur of the moment, he has taken the helmet and assaulted the complainant on her head. First, whether at all the petitioner had the intention to kill the complainant or not, murder the complainant or not, cannot be decided by this court at this stage. First, it is for the learned trial judge to form an opinion as to the alleged guilt of the petitioner after the full-fledged trial based on the materials available on record. First, it is too premature, TOO, too premature for this court to assess the merits or demerits of the case at this stage by holding a mini trial, as the same may prejudice the case of the parties during the trial one way or the other. Next para. Suffice to say that since the charge sheet is filed, and in the absence of any previous complaints, this court is of the considered opinion, that the petitioner is entitled for grant of bail by resorting to the special powers vested in this court under section 439 CRPC. First, next para. The apprehensions expressed by the prosecution can be met with by imposing suitable and stringent conditions. First, apprehension of the prosecution can be met with by imposing suitable and stringent conditions. Accordingly, following order. Section allowed. Petitioner is directed to be enlarged on bail by taking a bond in a sum of rupees 2 lakhs with 2 sureties for the like sum. First, petitioner shall make a separate residence till the conclusion of the trial. First, petitioner shall attend the court regularly. Petitioner shall not tamper the prosecution witnesses in any manner. Petitioner shall not leave the jurisdiction of Kodagu district without prior permission. Violation of any one of the conditions would entitle the prosecution to seek for cancellation of bail.